Thank you so much. Thank you, Congresswoman Garcia, for yielding your time. And I'd also like to extend my thanks to the chairman and members of the subcommittee for allowing me to join you today. Mr. Spindle, I had a specific question. The VRA contains express authorization for the Attorney General to seek preventative relief, including preliminary injunctions. Federal courts, including the Supreme Court, have long accepted that the VRA provides an implied private cause of action. Now, recently, in a brief concurring opinion in the Baranovich case, Justice Gorsuch expressed doubt about whether such a cause of action exists. Should Congress explicitly provide for a private right of action under the VRA?
Thank you very much for the question, Representative Scanlon. I think the answer is yes. I should make clear that I think the precedent is overwhelming that there is a private right of action under both Section 2 and other aspects of the VRA, but in abundance of caution, Congress should absolutely make that explicit.
Thank you. Ms. Weiser from the Brennan Center, as a representative from PA, which is north of the Mason-Dixon line, but nevertheless, we've seen a whole raft of legislation over the past decade, and particularly since the last redistricting, a series of laws that burden the right to vote, whether through gerrymandering, voter ID laws that would have disallowed voting by over 500,000 eligible voters. Why is it important to a state like Pennsylvania that we enact H.R. 4?
Well, the bill as Congress is currently contemplating it would both strengthen Section 5 of the Act and Section 2. Section 2 applies nationwide, and so that would ensure that even if Pennsylvania is not covered for preclearance, the voters would still have robust protections against voting discrimination that they could enforce. But that said, the dynamic coverage formula that this Congress is considering actually moves forward. New states that engage in discrimination repeatedly can become subject to preclearance going forward. So that should act as a deterrent to ongoing and repeated discrimination in states like Pennsylvania and other states around the country where there's a new push for discriminatory voting changes.
Thank you, I appreciate that. And I yield back to my gracious colleague from Texas, Representative Garcia.
Ms. Scanlon, without objection, if you have another question, you've been kind enough to be with us and spend several hours.
It's an abiding fascination of mine, this whole field. I would just ask then if any of the other panelists have anything they wanted to add with respect to the question about whether or not we need to explicitly provide for a private right of action.
Congressmember, I would simply echo what you've heard. It's clearly established that there is a private right of action, but given the ongoing assault on voting rights that we see, I think it would be helpful to make that clear as congressional intent. There's no question that the Department of Justice, even the most well-resourced Department of Justice, cannot do this alone. Even with preclearance in place, the Department of Justice cannot do it alone. I have the great pleasure of administering a consortium of 12 nonprofit organizations nationwide engaged in private enforcement of the Voting Rights Act. And I can tell you based on our monthly conversations that the work that they do is absolutely essential.